We are going to move on the next presentation. This is a very interesting one. The topic aviation insurance covers claims and controversy. This is a quite long presentation from Ngọc Thùy Trâm. Please start your presentation.
Okay. Hello, teacher. Ngân, can you turn off the slide? Ngân mà tắt slide đi. Okay, and the topic I will present today is aviation insurance, coverage, claims, and controversies. And the research is written by PAMELA. For many years, one of his primary areas of practice has been defending aviation-related claims, and this work has expanded his perspective on what insurance issues might come into play during the prosecution or defense of an aviation case, and give me a unique perspective on what aviation practitioners should be counseled as they navigate through an aviation lawsuit or any type of claim involving insurance. There are excellent in-depth treatises on aviation insurance, as well as articles about the risks, policies, provisions, but no general summary of what insurance issues the aviation practitioner might encounter. And this research is intended to fill that gap and provide a general overview of some common aviation coverage issues. And this research has 7 parts as mentioned below. And the first will go about the units aviation insurance market. The risk insurance in the aviation insurance markets are varied, but some common types of policies and coverage include aircraft manufacturer insurance, air cargo insurance, air charter insurance, aerobatics or experimental aircraft insurance, airline insurance, airport or ground handler insurance, crew insurance, lander insurance, fish-based operator insurance, flight training insurance, general aviation pleasure and business insurance, hangar keepers liability, rotograph insurance, space or satellite insurance, and unmanned aircraft system insurance. While general aviation risk and ground-based operations involve some of the same considerations as insurance coverage in other industries, the insurance provided to airliners is a distinctly unique market. In traditional markets, premiums are collected from large volume of insurers, providing capital to pay for a few losses and earning the insurer a reasonable profit over time. However, the aviation insurance market has always differed from most of other insurance markets in that both the premium base and the customer base are very narrow, which has a small number of insurers. The International Air Transport Association has about 230 members, a very small number of potential insurers. Is with potentially here is persons. A single insurer will not usually underwrite the entire amount of an airline's auto risk. Instead, a number of insurers will underwrite a small percentage of that exposure, thus keeping the exposure for any one insurer within acceptable limits. And now we will come to the insurance policies and the insurer duties. The components of an aviation insurance policy are generally the same as those of other insurance lines, but the specific inclusions and endorsements are unique to the aviation risk. In general, a policy is comprised of declarations. The insurance agreement contains exclusion and endorsement binders, which are temporary. Preliminary context of insurance might be the operative insurance content if an occurrence resulting in a large takes place before a policy has incepted or between policy periods. Duty to defend and indemnify. When a lawsuit is filed, an insurance first step should be to place or insurance carriers on notice of the claim or potential claim. An insurer then acknowledges the claim and make a decision as to whether they are covered, sometimes with the assistance of coverage counsel. The insurer generally has two distinct and separate duties to its insurers. The duty to defend, which requires the retention and payments of defense counsel, and the duty to indemnify, which requires the payment of a judgment for a covered claim. An insurer's duty to defend is broader than its duty to indemnify. In Louisiana, Texas, and many other states, whether an insurer has a duty to defend is determined solely by comparing the allegation against the insured in the complaints with the terms of the policies at issue. The so called eight corners, but sometimes calls for corners rules, but in some situations, the court will go beyond the eight corners of the policies and complain to examine the two facts to determine the duty to defend. And the duty to indemnify is generally narrower than the duty to defend. This duty is triggered by the actual facts establishing liability in the underlying suit. In the aviation context, the dichotomy between the broader duty to defend and the more limited duty to indemnify is illustrated in off-force aviation's global aerospace. In the underlying suit, a customer sues a repair station for breach of contract, breach of warranty, and other state law claims. And the complaints allege that one of the plane side windows cracked during the flight home from the repair station due to a forced negligence and faulty performance. So, what is the truth behind the story? The insuring agreement in off-force commercial general liability policies states that it applies to claims for bodily injury or property damage resulting from your aviation operations, but apply only if the injury or damage is caused by an occurrence and takes place in the coverage territory. Of course, as the insurer to defend a lawsuit filed by its customer, the insurer disclaims both coverage and the duty to defend. The court determined that the cracked window could have been a particular part of property on which of force performed work, because an invoice attached to the complaint mentioned the use of procedure on the window that were not furnished or installed by of force. And the court recognized that if the customer proves its case against of force, and the duty to defend is triggered by any realistic possibility of any damage that might be within coverage and outside the exclusions, and the damaged window creates that propast. Third, the court held that the insurer had a duty to defend of force. However, the court handily retracted of force by faith claim against the insurer. And last, the futurity requirement. Since the very basis of insurance is to protect against accidental losses rather than intentional acts or breaches of contract. It should be axiomatic that an insurance policy cannot cover losses that are not fortuitous, losses that the insurer knew about or should have known about at the time it purchased a policy are not covered. These concepts are generally known as the fortuity doctrine, the loss in progress, or the now loss rule. Under the doctrine, insurance coverage is preclude where the insurer is or should be aware of an ongoing progress or now loss at the time the policy is purchased, not at the time of the retroactive days in the policies. When there are many insurers, at least one court has held that fortuity is to be evaluated from the insurer perspective, such that if one insurer now has a loss, all insurers are precluded from obtaining indemnity under the policies. And courts in California recognize fortuity as a basic insurance concept because insurance protects against risk of loss, not certainties of loss. The California legislature codified the concept of fortuity is in the state insurance code. Accordingly, a plaintiff seeking insurance coverage for a loss must show that the claim loss were fortuitous. About insuring for punitive damage. In Fairfield Insurance Settlement in Payee, the Texas Supreme Court responded to a certified question from the Fifth Circuit as to whether Texas public policies prohibit a liability insurance provider from indemnifying an aware for punitive damage imposed on its insurer because of gross negligence. And importantly, the insurance policies as issued were workers' compensation policies, and the courts regularly held that the public policies of Texas do not prohibit insurance coverage of exemplary damage for gross negligence in the workers' compensation context. The court in Fairfield did not discuss the word accident or its definition under Texas law, but interpreted Texas public policies. First, outside the workers' compensation context, the question remains an open one under Texas law. 25 states have generally determined that public policies do not prohibit insurance coverage for punitive damage. 8 states prohibit coverage for such damage. 7 permits coverage, but only when the insurer liability is serious, and 3 states permit coverage in the context of uninsured motorists. And in contrast, 2 states prohibit such coverage. Thus, a good starting point for answering the questions of whether punitive damage and insurable is to review the Texas Supreme Court's discussion in Fairfield. The loss payee clause. A loss payee clause generally provides that the proceeds of an insurance policy are to be first paid to a designated loss payee, typically a lender, rather than to the named insured. If the loss payee clause is open or simple, it provides that if an insured loss occurs, the proceeds first go to the lender. The lender's rights are no greater than those of the named insured. In contrast, a standard or union loss payee clause resolves additional separate obligations onto the lenders. If the policies do not provide coverage because of the named insurer actions or neglect, the lender is protected. If from primary means Luke Ready Air LLC, the owner of a King Air 200 200 was called into turning over the aircraft to an individual representing himself as an agent of the government of Guadalajara, Mexico. The agent presented the owner with a solicitation order and won $100,000 to a broker representing the owner, believing incorrectly that the remainder of the aircraft purchase price was before to him. The aircraft was turned over to the agent. The broker never receives the balance of the purchase price, and the agent disappeared along with the King Air. The owner's lender was named as a loss payee on the aircraft insurance policies. Both the lender and the aircraft all made a claim for the loss under the policies. And the hint of this story is the policies contain the following exclusion. We will not pay for the loss of damage caused by or resulting from any of the following, such as wrongful conversions of the covered aircraft, voluntary parting with any property by you or anyone else to whom you have entrusted the property, if include to those sold by any fraudulent scam, device, or false pretense. Besides that, the policies also contain the coverage under the finance endorsement. It means the coverage provided by this policy to legacy bank will not be invalidated any acts or omissions of any other person or organizations that results in a breach of any term or condition of these policies, provided that legacy bank has not caused, contributed to, or knowing control of the acts or omission. And the lender argued that the endorsement should be read to preclude the application of the exclusion to its claims. And in conclusion, the court disagrees, acknowledging that while the bank claims do not depend on whether the aircraft owner's loss were covered, the loss still must be within the policy's coverage and not subject to exclusions. Okay, and now we will go to part choice of law. Before starting this part, we have questions. In the event of a dispute between insurer and insurers, which law is applicable to the dispute? Traditionally, aviation insurance policies do not include choice of law provisions. When a policy is silent, what law controls how the insurance context is interpreted? Texas and a number of other states apply the most significant relationship. That's from the state restatement second of Congress when deciding choice of law question, and sentences list the general factors for a court to consider. The needs of the interstate and international system, the relevant policies of the forum, the relevant policies or of other interested states, and the related interests of those states in the dissemination of the particular issues, the protection of justified expectation, the basis policies underlying the particular field of law, certainty, predictability, and uniformity are results, and the last is in the dissemination and application of the law to be applied. When determining a contract dispute, Section 188 lists additional factors for a court to consider. First, the place of contesting. Second, the place of negotiation of the contract. The place of performance. The location of the subject matter of the contest. And the domicile residence, nationality, place of incorporation, and place of business of the parties. I'll assume that an insurer in a Delaware corporation with its principal place of business in Massachusetts and that it issues a policy to a Delaware corporation with its principal place of business in California to cover claims brought against the insurer within the United States and elsewhere in the world. Of course, following the restatement choice of law analysts would likely give the place of contesting and negotiation greater weight if the evidence shows that the both occurred in California. And the place of contesting is the place where the laws are necessary to give the contract binding effect occur. If the evidence shows that the policies were contested, negotiated, and delivered to the insurer in California, a test that courts could widely apply California law to protect the certified expectation of the party and to foster certainty, predictability, and uniformity of results pursuant to the principle of statistics. However, if the evidence shows that the parties contested and negotiated from office and in different states, a court will likely give those factors little weight. And as in the aviation context, the policies cover risks located in multiple states. The location of the risk is insignificant. Accordingly, the residence of the insurers could likely become the determinative factor in the choice of law analysts, as explained by one court. The most logical way to meet the parties' certify expectation when a policy cover property in multiple states is to apply the law of the insured state or of incorporation or principal place of business. In contrast, when the risk insurer is for a general aviation aircraft operated primarily in a single state, a cost might give more weight to where the insured property is located. And for insurance and defense counsel, it also triggers the insurer's duty to defend. Defense counsel will be assigned to defend the insurers. Defense counsel must have a sufficient understanding of the possible insurance issues involved to fulfill their obligation to defend their client. This means what insurance might be available. From the outset, counsel should be aware of what potential insurance coverage they for a particular claim. There must be additional or excess coverage from policies other than the primary aviation policies. Knowing the full breadth of the client's insurance program is also essential for making appropriate disclosures during the course of the lawsuit. And confirm if the defense is subject to a reservation or right. Whether the insurer is being defended subject to a reservation of right can have effect on privilege issues. If an insurer is defending under a reservation of right, an insurer to hire independent counsel at the insurer's expense. Whether defending under a reservation of right triggers the right to independent counsel varies by state. Although defense counsel should be aware of and investigations of insurance, is it not the role of defense counsel to but not comment on matter of coverage if there are coverage issues that arise during the course of defending the suit? The insurers, or both should retain independent coverage counsel for advice. And for protest privilege communication, there are no general privilege between the insurance companies and their insurers. Importantly, the fact that there is no explicit protection for insurers and insurers communications does not mean that the communications are not privileged. There are other privileges such as the attorney-client privilege, attorney work product doctrine, and common interest or TRAM defense doctrine, and the absence of a general insurance privilege does not preclude the applicability of other recognized privilege that arise in the course of the insurance relationship. If an unqualified defense is being provided, there are little danger that communications with the insurers could ever be discovered as the interests of the insurers and insurers are aligned. A policies will typically have a cooperation clause requiring the insurer to report to the insurers and cooperate in the defense. A typical cooperation clause might provide you and any other involved insurers must first immediately send us copies of any demands notice, summons, or legal papers received in connection with the claim or suit. Authorize us to obtain records and other information. Cooperate with us in the investigation or settlement of the claim or defense against the suit. And last, assist us upon our request in the enforcement of any rights against any person or organization which may be liable to insure because of the injury or damage to which this insurance may also apply. And the outcomes of an insurance coverage issues can often be determined by actions that take place soon after the loss. When the notice of a claim is made promptly and correctly can be the difference between a loss that is covered by an insurance policy and one that is not. Various procedural mechanisms can also be outcome determinative. In the aviation insurance context, it is important to appreciate the issue to options, the best outcome for the client. Having a general understanding of the insurance duties and common coverage issues in aviation policies should assist counsel in providing sound advice to clients. And that's the finish of my presentations. Thank you for listening.